Everybody were telling that, arbitration mediation is the next big thing for me.
Compromise means you are settling down with something less than what you are entitled to.
What made you to say that aspect?
Compromise is not a good formula. The stick is in my hand. You should very attentively listen to my problem.
Nice. We always come to the student aspect of the law. They are the future of the law.
One should be a teacher by choice. Teaching is a passion.
100 people, 100 students in the KSLU takes part in the exam, only 12 to 15 people will pass in that exam.
Right to fair assessment is a fundamental right.
If you teach them in the right direction, they will be an expert in that subject. It's a double-edged sword, which I feel. You have been a professor, a teacher, more than anything, friend for every student for 37 years. Is there something which you want to share for the journey?
Being surrounded by these youngsters, I never felt that I am aging. Sharing of knowledge is very, very important. Before I leave this world,
That the ADRS, the alternative dispute resolution, the mediation, the conciliation, all the arbitration, all those things. So you said that if you're the reason you get draft a contract so precisely, both the contract, both the parties, lawyers go through so much of contract act rigorously, is to make sure when there's a trouble that their side get the best possible win. So you go to the court expecting a win, but when you go to the arbitration, you don't get a win. You have to compromise at certain level. So that aspect, sir, as to because everybody were telling that, arbitration mediation is the next big thing for me. But the compromise part was something which was brushed under the carpet by everyone for me. So what made you to say that aspect?
it is all because of my reading of one book written by Stephen Covey. The title of the book is Third Alternative.
Oh, okay.
Okay. Otherwise, Stephen Covey is a bestseller, 7 Habits of Highly Successful People, and all these things are there. The 8th Habit, Living 7 Habits, and all these things are there. And I stumbled upon this. There is a chapter, Third Alternative at Law. That caught my attention. Then I said, I will read this. Very fascinating chapter. See, when we speak of alternative dispute resolution systems, we have to understand one primary thing. Why dispute resolution? Whether it is mainstream or alternative, why we speak in terms of dispute resolution? See, disputes affect development. At the individual level, at the institutional level, at the national level also, disputes. See, countries at war will be spending a huge portion of their budget on arms and ammunition when children are getting the minimum education, health facilities and food. But because they are at war, they have to prioritize their expenditure. So like that, disputes affect development. Dispute at any level. And the purpose of life is to live a quality life. Okay? Who is living a quality life? A person who is at peace is living a quality life. Quality of life is to be measured in terms of peace at heart. He may be a Karodpati, but he may not have peace at heart. He is not living a good. He is owning assets. He is not at peace. He is not living a quality life. He is living a rich life. You can say whatever. So that is the thing. So quality dimensions are very essential. So dispute resolution adds quality dimensions to life of individuals and the institutions. That's why disputes, not to know dispute resolution is to be functionally illiterate in the society. Any person worth his learning, knowledge, intelligence, first he should not run into disputes. And by chance, if he has run into disputes, he should know what is the quickest way back to get out of that dispute. One is our mainstream dispute resolution system, court system, adversarial. Okay. And this adversarial system has run into problem because of the docket explosion, because it has become resource-based, so many criticisms. Because of all these drawbacks, we started thinking in terms of alternative dispute resolutions, mainly negotiation, mediation, arbitration, conciliation, some hybrid forms, combination of different forms of some indigenous sui generis systems, alternative. Alternative dispute resolution systems, especially things like conciliation and mediation, they are all appreciated because of one reason, that as it happens in the court, in ADRs there is no winner, there is no vanquished. Okay, win-win situation. We call it win-win situation. Okay. See, court is resource based. Okay. And alternative, now arbitration has become prohibitive. Otherwise, other methods are not resource based. They are, say, accessible, you can say. And in court, we fight litigation on the basis of rights. It is rights based. Dispute resolution in courts is rights based. Dispute resolution in ADRs is interest based. Okay. In court, dispute will not come to an end. Litigation comes to an end. And there will be appeal. And even after the final appeal, dispute will continue. Case is settled. Dispute will not come to an end in courts. But in ADRs, dispute comes to an end. Okay. So this is the difference because of which it serves the interests, and dispute is resolved once for all. Enmity will not continue. For all these reasons, we recommend ADRs. Wonderful systems. But when I read this book, wherein he emphasized upon this word compromise, we encourage people to arrive at a settlement, compromise settlement. And even in courts also we accept compromise decree. What is it? Compromise decrees. And all these things. And he says compromise means you are settling down with something less than what you are entitled to. That's why it is called compromise. He says compromise is not a good formula. When you advise your clients to compromise, you are asking him to settle down for something lesser. And both of them are compromising. Okay. So looking from that angle, what he advocates is third alternative. Third alternative works in a synergetic manner. Synergy is, see, when I perform a task, I am at this level of efficiency. You are performing the same task, you are at another level of efficiency. If together we perform the task, add both of these things, and we will get something more than that. That is synergy. When anything works in a synergetic manner, it will add the performance of both and it will yield something more than that. That is synergy. So he says disputes are to be resolved in synergetic manner, and therein he speaks of what is this? Talking stick formula.
Okay.
Which is the African tribal method of resolution of disputes.
Okay.
And he has given the picture of the talking stick also in that book. What is this talking stick? We are in dispute. Okay. Now the stick is in my hand. I have right to speak now. When stick is in my hand, I have to speak. When it comes to you, you have to speak. I have to explain my problem to you. You should very attentively listen to my problem, understand my problem, and after I complete narrating my problem, you have to narrate my problem back to me so as to convince me to accept that you have understood my problem.
Oh, okay. Nice. Mm-hmm.
So you have to listen, you have to very carefully follow what is my problem in this dispute. And having understood, you will put it back with the same emotion, with the same vehemence as I feel, you will feel and put it back to me.
Mm-hmm.
So once I am convinced that you have understood my problem, I will hand over the stick to you.
Okay.
Now it is your turn
Yes.
to explain your problem.
Mm-hmm.
And I have to listen. I have to completely understand what is your problem. And it is like this. At the end of this, sometimes a dispute will not survive.
Mm-hmm.
Because you understand why I am behaving like this.
Yes.
I understand why you are behaving like this. Especially in interpersonal disputes, wherein personal relations are wherein we use therapeutic model of mediation, wherever children are involved, spouses are involved, parents are involved. neighbors are involved. In such situations, this is the best method. See, in this process, dispute will be like peeling the onion. So outer layer I have peeled. I am searching problem in this. No, go on peeling it off. At the end, there is no problem at all. So when people can understand, that is one of the best methods. Third alternative, wherein people are not compromising. People will get their due.
Yeah, okay.
That's how it happens. But ADRs, I tell you, sir, arbitration has run into problem. We enacted Arbitration and Conciliation Act. Then about the nature of power of Chief Justice to appoint the arbitrator. It ran into a lot of litigations, whether it is an administrative power or a judicial power. We went on debating till that SBP and Company versus Patil Engineering was decided finally. Then we ran into problem about the seat of arbitration, place of arbitration, and the challenges for arbitral award, Section 34, ONGC versus saw pipes, wherein additional grounds were. See, arbitral awards can be challenged only on limited grounds. But our courts, they have interfered so much, they have expanded their own jurisdiction. They are not ready to give up their jurisdiction. Okay, so the supervisory role of courts, both under Section 80, Section 8 of Arbitration and Conciliation Act and also 34, it has increased. Okay. So judicial supervision of arbitral awards and judicial review of arbitral awards became and because of this type of interpretation, India is not a favored destination for arbitration now. It has gone back to Singapore and London. Okay, this is one thing. And another, arbitral awards also have run into problems. Maybe you have read of some arbitral award in international arbitration. It was a sort of copy-paste of arbitral award which was, say, rejected. See, we became a sort of laughing stock because
Yes.
dispute resolution.
I remember that judgment. I mean, like that arbitral award, yeah.
We should not be looking at arbitration or any dispute resolution process in such a simplistic manner. And for your information, you may be startled to know that Government of Karnataka has taken a decision not to insert arbitration clause in any of their contracts. There is a circular issued. There should be no arbitration clause in government contracts. Wherefrom we have arrived at what situation?
I mean, at one point we are trying to, celebrate the mediation week. We are trying to have that,
mediation is right in its place, but arbitration has run into problem. And arbitration has become again expensive. That is not, say, affordable or accessible thing unless big money litigation is involved and all this.
It has become to an access to the rich, I feel.
Yeah, that is the problem there. So, because courts were resource-based and courts were expensive, we thought of arbitration. Arbitration has... See, there is a problem in that. Okay? When we go to the roots, who are these people who sit as arbitrators and who appear before arbitrators? They are all people who are trained in adversarial process. The very language is very crazy. You and me are adversaries. Okay, we say learned brother, but we are adversaries. I am a party, you are an adverse party. We are opposing each other. In courts, we oppose each other. Okay, and what is the language that we use in the courts? It is a combative language. I will demolish the case. You have hit it on the nail. See, the type of language, see, these are the people who are trained in that adversarial system. Now you have given them this another instrument which is not adversarial. Okay, when the same people are asked to play a different game, maybe they are not in a position to come out of that adversarial thing so quickly or easily. That's one thing. And arbitral awards being challenged indiscriminately. Again, why one should go for arbitration? When again it goes back to the same court system. We have run into problems, and we have because of the say liabilities that were imposed on the government through arbitral awards, etc., etc. The figures may be alarming because of it. So, if the government issues a circular like that, there should be some very strong reason for that.
Then, like, are the courts becoming the problem, or the government is becoming the problem, or else are we completely not training the people to go through the arbitration or the alternative, dispute resolution system? Where the problem
Sir,
lies, according to you?
the problem is if we behave and conduct ourselves in such a way that people perceive us to be biased, we are losing the game. Okay? The way we behave and conduct, the way the arbitration is conducted, the way parties conduct themselves, the way awards are given, whether people in the government or parties, they should feel that justice is done. It is a fair award that is given.
But that's not happening.
See, once I perceive that the quality of the award that is coming out is not fair, I will not go to that, because anyway it is alternative.
Don't you think, because, the arbitration, all those things happens behind the closed doors?
So
Right?
parties are there.
Parties
no?
are there.
Parties are
But
there.
when there is a government which is involved in the same arbitration, because in the court, whatever happens, it's a public document, anyone can access, anyone can see as to how the government fought the case, what happened. I'm not speaking about the private parties. Private parties, they can have the discretion. But when the government is choosing to go for the arbitration, or if they choose in the future as to they want to go for the alternative dispute resolution, do you think the fairness as to what is happening inside of that mediation or conciliation, whatever it is, will be as transparent as to what will be happening in the court?
No, confidentiality will come depending upon the agreement of the parties. Okay, confidentiality clause will be there, then whatever that is decided to be confidential will remain confidential. But when it comes to the point of
Transparency, like I'm speaking about.
no, what happens is in arbitration also, like in the courts, we have claim petition and we have the defense. So everything is written, submitted, and even arbitrator also cannot be arbitrary, because there are obligations imposed on him under the arbitration and conciliation. He should be unbiased, and all these things are there. But it all depends upon how party pleads his case, right? So if the outcome is to be fair, the other day when I was addressing prosecutors, I told the same thing. If so many special public prosecutors are appointed, what it means? It means as a department, you are not up to that requirement. That's why special prosecutors are brought. And in the training, I told you should perform to such a level that there will be no hiring of the services of special prosecutor. Right? As an institution, arbitration has to excel, especially our arbitration. It is crowded always. Whenever I go to Bangalore Arbitration Center, there are 5 halls. All of them are always engaged and busy always.
Yeah.
But we should not, because we are trained in adversarial system, we should not spoil this institution, which will yield good results. That's one thing. And second, now Mediation Act also is in place. And you are aware of the fact that Karnataka has amended Civil Procedure Code, which has received the assent of the President and which is notified, which is law here, wherein once a litigation is filed, once a suit is filed,
It has to go for the
it has to go for
mediation.
compulsory mediation. And say because mediation is a better choice, even if 5% of the cases are going to be resolved through mediation, that will be lot of gaining for the judicial system, because to that extent docket will come down. And there will be no appeal, because that is the accepted settlement. That is thing. So here and there, wherever necessary, ADRs are to be pressed into service. And one The big issue that we stumble upon whenever we speak in terms of ADS is who will pay the advocates if you settle the dispute. If you negotiate and settle the dispute, if you mediate and settle the dispute, what happens? Litigation, every hearing there is a fees, some practices are there. You know it better.
It's directly eating the bread and butter of the lawyers.
And here there should be change in the societal perception of ADRs also. So it is a professional service, and the service is rendered by a trained person, professional person who has spent years in acquiring that. So I am given to understand somewhere else, if you get the dispute resolved at an earlier stage, you will get more fees. So such systems, such transformation should come here in terms of, because professionals incidentally they have to earn their food, not even if it is major purpose. But for any reason, we should not spoil the institutions. See, with all that under World Arbitration Act, that Renu Sagar's case, there is a often quoted para in that. The way arbitral awards are indiscriminately challenged before the courts has made lawyers laugh and legal philosophers weep. That is the expression there. So to come out of this situation wherein lawyers will laugh and philosophers will weep, we enacted new arbitration and conciliation, and we have gone back to the same situation wherein again lawyers laugh.
But will India ever become what is Singapore right now for the ADRS? If yes, how many more years it will take with current trend and current situation where we are taking one step ahead, 5 steps behind?
Let me be very frank, I have only theoretical knowledge. I learned through reading law and case law. See, there should be a restraint on the part of the courts not to interfere in the arbitral processes. And unless we have this restraint and confine judicial interference to only those specific things which are contemplated under the Act, India will not become a favored destination for arbitration. And another thing is execution of the awards. That is, how efficiently the system permits execution of the awards is also very important. India was initially, it was rated better, but maybe the way specialized agencies have come now, certain of the youngsters of your age and slightly above you, they have done their graduation in dispute resolutions from different countries, and they are specializing in arbitration laws. There are exclusive firms who are known only for appearing in arbitration cases. Once specialized things come, maybe, but given the range of litigation and the type of, say, culture, litigating culture we have, that will also continue. But wherever efficient dispute resolution is, see, going back 30 years, because of one injunction order given by a magistrate, a company like Cogentrix became insolvent. Investment, no, foreign investment and all these things. Things are at stake when courts interfere. That's why we have to think in terms of, so wherever it is big money litigation, resource based, wherein highly technical things are involved. Judge is a generalist. Say in mergers, takeovers, construction industry, we need specialists, no? And that is possible only in arbitration. That cannot happen in judiciary. That is the thing. So arbitration has its place, but all the parties have to play it in a proper manner so that we will become a favored destination. And we need training also in that area.
So coming to the end of the session, sir, like we always come to the student aspect of the law. Any conversation, any guest we have, because end of the day, they are the future of the law. They are the one who carry on this profession, the future of the country, in fact. So two questions I have. What is that one thing where the law school are keeping the students in blind, which you feel they are not teaching them in a right way, something which the law students have been misled when they join this profession, or when they are already joined, when they are pursuing this career? What is it according to you?
See, this is a very, say, it is a sort of paradoxical situation. So when I took over as principal of the law college in Dharwad, I went to the Bar Association and I addressed them. Look, there is a law college here and you are the bar. You owe a lot of responsibility to our institution. Because when students come out, they say what you teach is different and what is there in the court is different. Then there should be something wrong. Either we should be teaching wrong things which are not relevant, or you should be doing something which we have not taught.
Yes.
This cannot go like this.
Okay.
We should teach what is required in the court.
Yes, that's
That's
right.
why I request all of you to visit my institution whenever you are free.
Mm.
If I am going wrong, hold my collar and ask me to change the curriculum, practical training, whatever it is. This is the requirement. Ultimately, these people should be professionals. But what is happening is there are some disturbing situations. One should be a teacher by choice. And for your information, after my LLB, I have not enrolled as an advocate. After LLM also, I have not enrolled. The program is not to enroll, not to become an advocate. My program was to become a teacher. And I put myself on experimentation for 8 years. I was taking all my friends to my class to take feedback as to whether I can continue as a teacher or not. If my friends are to certify that you are not fit to be a teacher, I felt in the initial years itself I will go out so that some better teacher may be there. Right. Teaching is a passion. Unless I am so passionate about it, because I will affect 30, 35 batches. Yeah. So many thousand students will be affected because of this bad teacher. I should give my best. Quality teachers is very, very important.
I've seen
I have to learn first.
Yes.
See, I can teach what I am.
No, I've seen people, sir, where they were telling, I ate Contract Act, I ate Constitution of India, I ate, XYZ, IPC, I mean, like, or else BNS, because my professor didn't teach me well and I struggled a lot in that subject, or else the concept how they taught me the said subjects, I never understood it. So I doesn't like that subject because it's a trauma or something which they carry throughout their lifetime. If you treat them and if you teach them in the right direction, they will be an expert in that subject. It's a double-edged sword, which I feel. And the second question is that, sir, like, it's a harsh reality. I'm I'm a student of the KSLU. Recently, I guess like 2 to 3 years ago, they had filed an RTI. If you know, I mean, like, you'll be knowing it. What is the pass percentage of the KSLU? It was around like 12 to 15%. So if 100 people, 100 students in the KSLU takes part in the exam, only 12 to 15 people will pass in that exam. But when you go for the private university, they are literally passing the exam even before they write their final exam because of the extracurricular activities. So, like, why that partiality? Like, I mean, more than partiality as to what is happening over there. KSLU students 12 to 15, whereas the private university student can pass before even he writes the final exam. Is this because of the discriminatory between the government aided college and the private aided college? What is it?
No, it is it is like this. In KSLU, nobody is employed in KSLU as a faculty member to value these papers. KSLU faculty members value the papers of KSLU Law School. They have an honors program. BA LLB, BB LLB, BCom LLB, honors program they have got. They value those papers. And as far as the papers that come from 100 and odd colleges all over Karnataka are concerned, we have a panel of examiners from all the colleges. Whoever who has completed so many years of service, the list will come from the college and the consolidated list is there. Now papers are scanned and they are dispatched to different 6 centers all over Karnataka, wherein teachers of these very colleges come and value. Okay. If passing percentage is less, if anybody complains, he should understand that it is their own teachers who are valuing. Okay, it is
Okay.
the teachers of all these colleges who are valuing,
Okay.
and it is see if there are problems. See, it is like this. There are three parts we have to understand. In running an academic institution, there are three parts. One is curriculum making, one is curriculum delivery, one is examination. Okay, appropriate syllabus, appropriate teaching, and then examination. There should be a sort of compatibility between these three things. Okay. For your information, I tell you, I have to deliver good lessons, preparing myself from the standard prescribed books. And attendance is compulsory. He has to attend the classes, minimum 70% of the classes. And teaching, learning will happen. And examination, there is no question. All these people will see. What happens is, see, this 13-14% of the people are around, say, in final year, 30-35% of the people, they are regular students. And maybe there is a mature student who is irregular but who also clears the examination. But these numbers are to be bothered about, there is no confusion. Okay? All of them who are in charge of legal education, right from principal to the last teacher, including guest faculty, whoever who is there in any institution should strive. They should say, I was part of the university, no? When I was attending one meeting in a private college, and then the management people asked, I was acting vice chancellor of the university. Mr. Vice Chancellor, some of our students want to meet you. Will you meet them? I said, they are students. Ask them. So all of them were brought and they were all standing in two rows. Then what is your problem? Then somebody said, sir, four papers I have scored more than 60% and one subject I am given 20%. Somebody said, see, 2 semesters I have cleared with this thing and third semester 0 result. Each fellow has his own problems. Okay. I heard all the problems. Then I said, anything else? No, this is all. Then I told the management, call all your teachers. They will answer these questions because they are the people who are valuing these papers. There is no one in the university. They have to do justice. I tell you, sir, right to fair assessment is a fundamental right. And a teacher is not supposed to discriminate. He has to give the student his due. And we have to play this game. See, we are not regulators, we are educators. And we are sending out these people. If we send out quality graduates, that will bring respect and reputation for the profession, for the institution, for the families. See, ultimately, respect. And I am not to speak about what happens in the private institution. But one thing I tell you, all those people who are adorning the best of the constitutional positions are from these colleges. Okay. And it is these people who are serving the nation, but that is not an excuse to strive towards higher things. It is always there. Maybe things will go wrong, that's why you have provision for valuation, revaluation, but again that is against a fees that is to be paid. Nothing like good valuation in the first this thing also. Maybe in days to come, as technology improves, when we get, say, document reading AIs, if papers are valued by AI, then all this human error will be eliminated.
Yes.
Then there will be no complaints. Or there may be complaint that AI is biased. That's it.
So, coming to the end of the show, sir, like you have been a professor, a teacher, more than anything, a friend for every student for 37 years. Is there something which you want to share for the journey? Like, it's an ongoing journey, but so far.
Yeah, it is a wonderful experience to be a teacher. I am the person who is benefited by the way I have lived. What happened is, I am always surrounded by youngsters who join me after PU. That is at the age of 17, 18, they come and they will be with me up to the age of 22, 23. Being surrounded by these youngsters, I never felt that I am aging. So now I am as good as a fresh graduate who has come out of the law school after his 5 years program. And life is highly satisfying because when children come back, when the children share their experience that they are appointed to this position, this post, and they are empaneled here and there, or they are earning well, they are well settled, that gives me a lot of satisfaction. And following the footsteps of my elders, my teachers, and all those great professionals, I continue to be a student of law. And sharing of knowledge is very, very important. And whatever I learn, I have to share with others. There is a concept, die empty, a book written by Todd Henry. Before I leave this world, I should share all the information that I have with me with somebody else so that it can be propagated. Ideas should not go to graves with the individuals. So I am involved in this process of learning, sharing information, and the government of Karnataka has given me this coveted position of heading the Karnataka Institute for Law and Parliamentary Reforms, for which I should remain grateful to them for adding another quality dimension to my life, wherein I am participating in policy making also. And the most wonderful thing is various universities, various institutions, professionals, and law students are part of this journey. And it is the people, the colleagues, the students, the professionals who have made my journey so beautiful. All credit to all of them, and I am grateful to all of them for this. And a special mention, La Seva. I understand this is all resource based.
This podcast is Coffee
Everything
with Counsel.
costs.
Yes.
Everything costs.
Yes.
And at this age, you have taken up, you have embarked upon this journey of knowledge creation and knowledge sharing, which is very, very essential. Ideas through your program will reach so many other people. This is a wonderful exercise which you have undertaken. Compliments to you.
Thanks a lot, sir.
And I only feel jealous that all these things were not there when I was of your age. But at least I am so happy that I could be part of this program. Thank you very much for the opportunity.
Thanks a lot, sir. I mean, like, credit goes to my team as well because there are a lot of people involved in this. So, yeah, sir. I mean, like, and any last message for the 18 or 19-year-old kid who's planning to join the law, or else person
Sir,
who's
law-
studying the law?
See, now law has become a career option. That was a time wherein people were saying when the fellow is not getting admission here and there, he is coming to law program. Now law is a career option and it is a noble profession. And the type of specializations that have opened up with the technological revolution, I tell you, there are very, very great opportunities. Great opportunities to make name, fame, earn, hold positions. And law is a center stage profession. You have to understand this. The doctor, highly qualified surgeon, he has to remove his suit and put on the scrub and go into the operation theater. He is such a wonderful scholar, but his skills nobody will come to know. What he does, nobody will understand. If a doctor is asked to speak in a stadium, nobody will listen to him because his language is different. But a lawyer can stand in any stadium and see, it is a center stage profession. He will put on his best of the suits and come on the center stage. And so you will have name, fame, glory. You can live a unlimited, unmatched life. Take it as an option. See, sports law is developing, entertainment law is developing, technology law is there. In every walk of life, health law is there. So highly specialized, focused, professional options are there. You can take that. And if you are a person who has a flair for public life, if you want to stand tall, and if you want to become a leader, so we say law is an overarching profession. No other profession can survive without our profession. So you can play leaders as a professional, all the opportunities, but once you take it up, you have to pursue it with passion. Professionalism is required. Uh, when you are a student, you should be having those problems. There is a wonderful book, Subrato Bagshi, The Professional. 3 criteria for a professional. As a student, I should be professional. As a lawyer, you should be professional. As a teacher, as a student, you should be professional. What is that? First requirement of a professional, work unsupervised. I should be in a position to work unsupervised. My boss is not there, my principal is not there, my teacher is not there. I am a student, I will do my job, whether somebody is observing me or not. Second, certify the completion of your work. I should be happy about what I have done. I have written an assignment, I should be happy about that. I have taken an examination, should be happy about that. I should certify. Anybody can be a professional. A driver can be professional, a sweeper can be professional, provided he derives that satisfaction after completion of that work. That is certifying completion of work. Third, integrity. He has to do this with integrity. So if you are going to be a student, a professional student, you will really excel well. There are a lot many good things in the store for you in the world of law. Okay, all the best.
Thank you, sir. Thanks a lot taking your time off and coming on the show to educate people, as you rightly said, the knowledge sharing aspect, the bit. So hopefully we take some inspiration from you and to follow the way. I mean, to lead it further. Thanks a lot, sir.
It is mutual. I get a lot of information.
Yes.
Whenever I meet youngsters, and there is a lot to learn for me, especially in the area of technology. New things out.
Thanks a lot,
Thank you.
sir. Thank you, sir.
Thanks a lot.